Ms. Groen, can you hear us?
Yes.
Okay. Now you've plugged for audio, so if you start talking, and Lynn, if you can't hear somebody, don't hesitate to ask us to speak up, okay?
Okay.
Imagine that. It's the rain.
It is the rain. You just have to put everything on rain. Well, I have absolutely nothing.
Either rain or COVID.
Okay.
One or the other.
Well, let's go.
So, the court will call case number 54708 in the matter of the marriage of Eric Groen and Lynn Groen. Is the petitioner ready?
We are, Your Honor. Todd Mayfield, Cindy Graham here for Lynn Groen. I'm here on behalf of Eric Groen and the present ready.
So, we have, again, let's see, I know there is a motion to add a third party. Whose motion is that?
That's ours, Your Honor. If I may, I'll hand you a copy of the motion.
And then I believe, Mr. Burks, there also an objection to the scheduling.
Correct, Your Honor.
Parties have a preference which one we proceed with first.
I think the first motion for leave to add a third party would dictate the court's, well, certainly impact the court's decision to enter another schedule. It's just that motion for schedule. Do we have a speaker on?
Oh, absolutely. All right, to begin then, if Mr. Burge has an objection to going to the third party petition first.
No, Your Honor.
In that case, Ms. Groen's petition, so Mr. Mayfield, you may proceed.
Your Honor, thank you, Madam Chief of Court. We're here basically on a motion asking the court for leave to allow us to file a third-party petition against Eric Groen, who is, I'm sorry, against Curtis Groen, who is the father of Eric Groen, and our client's father-in-law in this case. Does that make sense to the party?
I'm making a note of that. So Eric Green is married to Groen is married to,
That's correct.
and Curtis would be Eric's father.
Correct.
And Lynn is now seeking to file a common, Mr. Kirkwood.
Yes, ma'am.
Yes, okay, you may proceed.
Yes, Your Honor. And this is a case based on essentially Texas Rules of Procedure 37, 38, and 39. Your Honor, we're seeking leave of the court as required by the rules based on timing to allow us to add this additional party at this time. It happens in many circumstances, perhaps not that often, in a family law matter. But what we are is we're seeking basically to add this third party on for two fundamental reasons. One of those is we believe that there's been some actions in concert, if you will, between father and son, which affects the community of property, affects the distribution of this money. Specifically, we believe that there's evidence out there, if we can discover that evidence, that will indicate that some of the money that should have gone to the community estate has in fact gone to the father, in this case, as Curtis. Your Honor, we believe that's been accomplished by the diversion of funds from the sale of certain crops. Those funds should have gone into the community estate. Because of that, the reasons that's listed in our motion, Your Honor, we believe that there's at least some possibility that we need to discover of whether or not they have actually committed fraud or worked in concert to deprive the community of those funds. That obviously affects the community estate. Secondly, Your Honor, in March of this year, we were informed that at that point, Cindy was informed, because I'm new to this case, that Father Curtis is asserting that the claim or debt owed by the community estate to him for $114,000 in gas. Now, the timing of that is critical, Your Honor, because it's my understanding, prior to my involvement in this case, there was a Rule 11 agreement in place that essentially ended discovery sometime in February. The way I believe this happened, Mr. Byrd informed Ms. Graham that the father was seeking reimbursement from the estate for a bill for $114,000 for a gas company, presumably to run pumps for irrigation. It's significant that that came in March, Your Honor, after the close of discovery. And so in order to adequately discover that information, find out the basis for that, how it occurred, why it occurred, and what the basis of those claims are, we're just forced into the position that we have to add the father to this case as a participant. Your Honor, the rules are very clear that third-party practice, it really comes into play in this case, that any time after commencement of the suit, third parties can be brought in. Now, it's 30 days after the original answer, one way or the other, we have to seek leave. And that's why we're here today. We're not asking the court to rule on anything other than to let us proceed in this fashion. Now, the rules, Texas Rule of Procedure 39 says that a person who is subject to service process and he shall be joined as a party in an action if, in his absence, complete relief cannot be afforded among those already parties, that certainly applies here, or claims and interests relating to the substance of the action is so situated that the disposition of the action in his absence may, as a practical matter, impair or impede the ability to protect that interest. You got clarity in this particular case at the conclusion of a well-past discovery, I guess, whatever the rating was at that time. We're provided, at least informally, a bill that they seek to obtain payment from the community estate. $114,000. I'm not talking about a $1,400 bill. We're talking about $114,000 that father of Eric wants to be paid back to them. That dramatically impacts fair notice of fair distribution of the community estate. And Your Honor, I think it's clear that the rules allow this. In fact, in a situation that fits just these facts, I really don't think the court has much leeway because the statute says it shall, they shall be. And all we're asking for, the court to grant that motion to leave. We can have father served, begin that process. Obviously, he's got all the length of time to file an answer to King Council if he so chooses, but we cannot obtain the discovery we need unless until he's a party. And moreover, if he is a proper party, if he's paying those debts, and we believe there will be evidence of collusion and trying to hide some of this money from the community estate, the only way we can get that is through discovery of him. And if he's done that, and he is a proper party, then he can be subject to liability just under tort, contract law, fraud, conspiracy, all those kind of things. That dovetails into the reason for the motion of another scheduling order. And we won't argue that point yet, Your Honor, but what we're asking for in that scheduling order, I put this off for very long. We're looking at a September date. That'll give us enough time to seek discovery, change documents, others wherever we need to determine the impact, if any, to the community estate. So the rules allow it. In fact, the rules require it. If so asked, that's what we're asking the court for today, is just leave to add him, father, I get the names messed up, as a third party in this case, Short, sweet, simple, that's what this motion is about. We'd ask the court to grant that motion for me.
All right, thank you. Do you have a chance, Mr. Booth?
Yes, Your Honor. This case has been going on for over 2.5 years. Okay? The claim that in their motion they say they just now discovered, pursuant to an email or text message between Lynn Groman and her husband on December the 18th of 2021. Approach, Your Honor.
You may.
This is number 2, this marks at the top. They're claiming this is newly discovered, but at least Mr. Groman knew about it in December of 2021. That's exactly what he just told you about. She says if you continue to do this, that, you know, they're going to subpoena everybody and they're going to do all this other stuff. Okay? That's this claim. That's what they're talking about. Now, I would also point out, this number 3 is the Rule 11 agreement between the parties. Wherein, after they knew that for over 2 years, we agreed, in order to get this thing tried, that all the amended pleadings would be done by February 14, 2023. Further, the argument that they have with regard to Morningstar Dairy, what their claim is this, and we deny it vehemently, but their claim is that Morningstar Dairy received these funds and that they were put into Curtis Growing's name instead of Curtis Growing's name in order to avoid the community issue. This number 4 is a subpoena against for other grand citizens. It was filed right. The reason why this becomes important is these are the records that they would be looking for. And I'll tell you, if you look at that affidavit of business records that's been filed, this is not just Eric Growing's crops. They didn't just get Eric's, they got Curtis's too. Whenever you look at it, it shows you what was put in there in Eric's name. That's the first sheet. And then if you go to the 2nd, 3rd, 4th, 5th, and 6th, that's Curtis's sheet. They've also subpoenaed Freon Industries, and I didn't put all the records because there's 154 pages, but I think it's important for the court to understand that kind of what has been done. They're talking about this. You know, this is the other people since the year before the process thing too. Can I approach it on?
You may.
This is exhibit number 5, which shows that all their records are filed. Exhibit number 6 is Faria Brothers Dairy. That's where the crops went the next year with regard to this.
You may.
Then I'm going to go to exhibit number 8, which is the polls. And they're the ones that cut the crop that year. That are that is harvested people. They're actually not the ones. I mean, this subpoena they've been sent with regard to polls.
Now, the reason why I handed you all these exhibits is they want to tell you that they need more time to discover this wrongdoing of Curtis and his dad. Well, first off, since 2021, they know about it. And second off, they've asked everybody in the country. They've subpoenaed everybody in the country. And as we sit here today, what I would challenge you to do is to ask them, what evidence do you have to open back up court? Because this court has the authority not to allow, unless they can prove there's a claim out there, then this court has the authority to determine whether or not a third party should be brought into a divorce. And they're not, what they're telling you is, and I paid attention to Mr. Mayfield's words, is we think, possibly, could have been. Those are the words he's using because they don't have any evidence, despite the fact that they had this contention since December of 2021. The other thing is, Your Honor, we went to mediation on this case not once, but twice. 2 different times through those mediations have we had this issue come up. It's not a new issue. It's not a surprise. It's not a surprise to anybody. And then with regard to, Mr. Gruen brought me this today, so I will show it to Mr. Mayfield and Mr. Graham, and if I need to get a copy of that and get it to them in court, I just got handed this letter, honestly, Your Honor. But according to the law, okay.
We got it.
Okay. So exhibit number 9 is West Texas Gas. And what they're saying is that that Curtis Gruen is making a claim against the estate. If you read that letter, West Texas Gas said, we billed the wrong person. They gave him his money back. And now we owe that money. And not only do we owe that money, but we've paid $60,000 for that money so far. And really what happened is, put my client up there. Curtis Gruen showed up on the farm because my client was out of town. West Texas Gas put a meter out there. This farmland is next to Curtis Gruen's. They just billed Curtis for Eric's gas for a year. Until Curtis figured out, hey, that's not my well. So now they're wanting to bring in Curtis basically for a debt that West Texas Gas says is wrong and let him out of it. So that's not, and also the other thing, Your Honor, is this will be the 3rd continuance in this case. And like I say, it's been 2.5 years. It's been a long month. We got a setting on the 21st. That setting on the 21st was made in February.
First of June.
Yes, ma'am. And so we'd ask that that be denied for those reasons, Your Honor.
If I may,
You may, if you will give me 1 minute, I've got to respond to an email.
Absolutely.
Give me 30 seconds and I'll be right back.
no problem, give me time. One.
do you want any of these put?
Yes. I'll. Okay. All right.
Thank you so much. All right. Mr. Mason, you may respond. Do what you see fit. Oh, absolutely.
Your Honor, I want to focus first, if you will, specifically on the rules of Texas civil procedure. One of the rules on 37. It says, before a case is called for trial, additional parties necessary or proper parties to the suit may be brought in either by the plaintiff or the defendant, on as terms the court may prescribe. The court certainly has that ability, but then you get to rule. The court has the ability to just say may. Because Rule 39 replaces may with shall. Your Honor, in Rule 39, a person who is subject to service of process shall be joined as a party in the action if, number one, in his absence, complete relief cannot be afforded among those already parties, or he claims an interest relating to the subject of the action so situated that the disposition of the action in his absence may, as a practical matter, impair and impede his ability to protect that interest. If he has not been so joined, the court shall order that he be made a party. I think it takes the discretion out, Judge. Where this comes into play, frankly, we could get into testimony from different people about what Lynn knew and when she knew it. She's always had a suspicion they were working in concert and all these different items to deprive the community of its assets. We can focus on that. That's something that can be discovered. But more importantly, Your Honor, is the timing of Exhibit Number 9, which Mr. Byrd just provided to you. Exhibit Number 9 is a letter dated February 28th of 2023. The letter from WTG Gas. Again, I'm not going to time it wrong this way, but I'm not trying to, because I don't know when the mediation occurred. February. So after the mediation, I guess the last mediation.
Yeah, that's it.
That's when this letter came out. And for the first time, my client, Lynn, discovers there's a claim made against the estate by the father of her husband. And it's beyond dispute, but that this letter, dated February 28th, didn't find its way to our client's lawyer, Ms. Graham, until sometime in early March. So this is new evidence, Your Honor. They're attempting to use after a time that's given informal discovery, but given at a time after the discovery for this Rule 11 had been closed. That prevents my client from adequately discovering the basis for this. That's what's so critical in the timing of this thing, Your Honor. And when you look at this claim that Curtis has against the community state, there can be no disputes. But the he claims an interest related to subject matter of the action is so situated that the disposition of the action, his actions, may impair or impede his ability to certainly impact my client's ability to protect her interest in the community state. That's prima facie evidence of new evidence that nobody has found. And the only way we can adequately discover all these other claims, let me back just a second. Something Mr. Bird said. He's asking us to put forth proof of our claims that they commingled these crops and did all this stuff. We don't have to put on a case to prove the merits of the case. And the motion to leave to ask the court to allow us to join a third party. And what's most critical about that is this letter, exhibit number 9, February 28th. This is new evidence of claims against the estate without the ability to discover the basis of this. And moreover, all these affidavits and things that were requested, with the exception of the very first one, which was DPS, was mistakenly done, that did Curtis's property as well. All this other subpoenas are information for Eric's estate, or Eric's business, for his farming operations, not that of Curtis. So, Your Honor, it would hamstring my clients and not allow us to adequately discover these claims. And they just present them to us. $114,000 to a lot of people, certainly me, is a lot of money. And without the ability to pursue this, and they're asking us just to take their word for it, and it was a mistake. I find it hard to believe. Somebody sent me a bill for $114,000 in a year. In over a year's time, I think I would have discovered that well before a year. I started getting these on a monthly basis. So, frankly, Your Honor, based on the timing, I don't think the court has discretion. I think the court must grant this motion to leave according to Rule Texas Rule Civil Procedure 39. And moreover, sure, this case is apparently been going on for a while. We're not asking for next year. That's part and parcel of the motion for entry of a level 3 scheduling order. We're talking about a setting in September. We're in June already. So we're not asking for a long time, but we need enough time to discover what the damage has been done, what damage has been done to the community estate, or what else is out there. As I understand it, and again, I haven't been in this case all that long, the rollouts, if you will, of the discovery response has been piecemeal. So as I understand it, there was a mediation, then we get more stuff. The second mediation, then we get more stuff. And so in an effort just to kind of put an end to the rollout, if you will, Your Honor, we believe it's appropriate for the court to grant a motion for leave and allow us to name Curtis as responsible third party to discover specifically this gas issue on exhibit number 9. We have no way of knowing about. And specifically on all these other items of his farming operation, because these subpoenas records pertaining to Eric's operations and not Curtis. I'm finally getting the names right, Judge. And not Curtis. So I think that's significant, Your Honor. And we're not asking for huge delay. We're just asking for the court to allow us to add him as a party, allow us to conduct discovery, and by processing in September.
I understand the 113,000. Are you also saying that there's some new evidence that Eric and Curtis have commingled funds?
That's what we need to discover, Your Honor. Here's the other issue.
But why would you not know about that before? This is email back in 2021.
Frankly, I think, Your Honor, that was a suspicion that Lynn always had. And when you really look at it, and that's one, I appreciate you bringing it up to remind me of another point. After the second meeting, before the second mediation, there's another issue that has cropped up, and that is that they drilled a new well. We didn't find out about that until then. So that's new expenses against the community.
Father and son?
I believe it's just son. Is that correct? That's what I'm talking about, the rollouts. And frankly, these are suspicions Lynn has on her part. And I think the evidence is looking at the numbers, they've not gone to the trouble yet to have some time to take a real hard look at it. But the numbers are different year over year of money into the state and these various farming operations. And we may be well placed, but this gas company issue, and if nothing else, Your Honor, that gives us the right to add him. And frankly, he's got a claim against the mayor of the city, he being Curtis. He's making it. And that affects what the community estate is. What's over. And we don't have any Curtis records because he wasn't a party, Your Honor. You know, individually, and the records we have from these various business entities that Wayne provided the court, Mr. Bird provided the court, pertains to those particular businesses, companies, and contain the records of heritage. Except for one GPS, mistakenly put in the court. And included, that's early on, right? That included Curtis and Eric in the same deal. But the rest of all those things, we don't have any records pertaining to Curtis.
But, other than the West Texas gas issue, which I understand is new, what is new about, other possible claims against? Why are you just now suspecting that they may have been disinterested rather than last year?
Frankly, Your Honor, I share this with the court. Our client was willing to just kind of let this stuff go. Really was. Until this gas thing pops up. And she's like, I always had my suspicions. They were co-mingling and hiding money, particularly towards the end of the marriage, if you will. So frankly, they just didn't pursue it until this gas thing comes up. And then the thought is, where there's smoke, there's fire, Your Honor. So, if the court, frankly, I think the court has to grant us leave to add him as a party, we want to discover those issues. The only way we can get that discovery is from Curtis. And there's a difference in third-party discovery and party discovery.
Mr. Wood, do you have a response?
I do, Your Honor. And first off, I'd like to admit the exhibits I gave you all over, because I did not admit them or ask them to be admitted.
Exhibit 2 through 9 are admitted. There's not an exhibit 1.
Correct, there's 6 and 8.
Or 3.
Your Honor, Madam Coach.
Yes, I have 2, 3, 4.
Three. I didn't have a three. Okay.
You don't have a number 7.
No.
4, 5, 6, no 7, and 8. 9 and...
1.
Any objections, Mr. Rico?
We have no objection, Your Honor.
Right. Yeah, exhibits, got those exhibits.
Right. Now, what Mr. Mayfield told you a while ago was really correct, and that is in Rule 39 says if there's no other relief or no other way to get relief, what number 1 is the immediate settlement agreement that we made. Now, if you didn't settle any issues except for the valuation of this property, okay? This is say on the community property owned by Mrs. Growing and Mr. Growing. Okay? We agreed to what the estate was basically worth. Now, there may be some claims made against each other and all that, but this is what we agreed to as to the work. Whenever you take the amount, the assets, that's $2,821,762.99. So $2.8 million in assets. And whenever you take the net, whenever you take what they owe to the bank and all that, it's $1.987 million stake. The reason why that becomes important is if my client committed fraud with his dad, you take that out of the estate. The law allows you to do that. As a matter of fact, in community property cases where you got a fraud on the community, that is what it tells you to do, is give her a greater share of community property. So if she's right, and she's not, we don't believe she is, we don't believe there'll ever be a proof of it. They've already looked at it and found it, but they won't look harder. But even if that's the case, they can get justice and they can get equity and fairness by you awarding her more of the community estate. And so it's not like this is negative in that they gave all the estate to Mr. Curtis Growing, such that he would have to be here in order for there to be fairness. If my client gave away $150,000 like they claim, all you got to do is simply subtract another $150,000 out of the $2 million. Put it on her side.
Is that 150 or is it 170?
Well, to me, the gas bill, and they keep on saying that's a new deal between Curtis. It's not a new deal with Curtis. You have the letter that sits in front of you that we produced as exhibit number 9. West Texas Gas refunded his money. We had nothing to do with that. We couldn't make them do that. They did it because it's the wrong one. If anybody's committed a fraud here, it's West Texas Gas. And they're not asking for leave to sue West Texas Gas with regard to the $113,000. What they're doing is asking you to do Curtis. All Curtis did is got payment back from a company that it wrongfully billed. And that's the importance of exhibit number 9. When I'm talking about the $150,000, is that's what they think that we put in his account or whatever you're going to say. The theory that is what she tells you in the text message is that he put that money in his dad's name.
No, in the text message, there's no.
Okay, but I think that, well, maybe that didn't happen today, but it's approximately $150,000. I mean, that's what we've been told in the past, the mediations, all that. That's the number they think that they're at. And I think Mr. Mayfield said that earlier. If he didn't, I'm sorry, I apologize. But I think everybody kind of agrees that that's the range. It surely is not. Nobody's claiming this $1.9 billion, I don't believe. And Mr. Mayfield, if I'm wrong on that, I'd ask you to request that he straighten me out. But there's a way to get justice.
Rachel, how do you respond to that I can equalize his refund here?
Well, in fact, you're going to have to, but you need to be armed with some evidence, Your Honor. This letter, which is exhibit number 9, to my knowledge, the first time we've ever heard, this letter doesn't say that. It's the first time we've ever heard by the representation made by Mr. Byrd that Curtis was paid back. That's not what this letter says. So we don't know that, and that's one of the reasons we need to discover it. There are types of it, frankly, Your Honor. And then on what Mr. Byrd has provided, exhibit number 1, where he goes to the very back of this mediated settlement agreements. These are simply the items. That's the last page. Next to last page. One's got the chart. As I understand it, these are the items upon which they agree. Not everything. So note on the liabilities doesn't have anything at all about the WTG. That's something that's come up differently. Certainly, the court has the right to equalize those things, but we're just left at a disadvantage when we're in a position that the rules allow us to bring him in. They don't want us to bring Curtis in. I get that. I do. At personal level, otherwise. But we have that right under the rules, Your Honor, not just to take the word for it, but to discover these items. And somebody, frankly, I can't believe Curtis didn't enter into this lawsuit of his own volition, because the rules allow that, to get his money paid back out of the community estate. Letter doesn't indicate on exhibit number 9 that Curtis has been paid back. It simply says that Eric now has a liability, $113,000. Clearly, that implicates and impacts the rights of my client, Lynn. So, to do otherwise would hamstring our client on being able to discover what really happened on this West Texas gas thing. And more importantly, Your Honor, it happened once, did it happen before? We can only obtain that information if we bring Curtis Rowland in as a party, properly discover this information, determine what other potential misuses of the community estate have occurred. And obviously, the bigger the estate, the more money there is when you divide it up, Your Honor. That's the bottom line when you look at this. And this on exhibit number 1 is simply those items which are agreed to. There's, I would presume, numerous others which were not. I think this was an attempt, probably at that time, to try to limit some of the issues before the courts. Court, that's what it said.
Okay, on this West Texas gas bill, it looks like Eric paid $60,000. Correct on that?
Yes, Your Honor.
So West Texas gas is going to be saying, you know, that this is some hindering of
113, that's 60, Your Honor.
Where's, I don't have any idea what the 60 certain part of that marijuana that should have this. Oh, I've seen that.
check your name.
Yes.
Mine's just 2 pages.
Not dedicated, you said you had.
That's just what it's from.
Yeah, but he just said that April.
April 28, 60,000.
We didn't know that.
John, that's just, again, another reason I believe that we should have to pay that at the end of April. I guess he's planning on paying the rest of it. Didn't know that. That's just going to have us going to trial in June. I don't need this stuff. June, we already in June. Realize it. So that's why, Your Honor, we're asking the court for leave to add this additional party to enter a motion for a level 3 schedule, or enter a level 3 scheduling order. Set the date of trial in September. And again, we're not talking a long period of time. In fact, I think we were talking about they're ready for trial date of September 18th, so a little over 3 months.
And Judge, if I may, since you asked the question, I would normally do sort of a family law education deal, Judge. Mr. Mayfield's here because basically the court received really more of a civil suit, a civil action. And that's why Mr. Mayfield's here, is just the regular family lawyers in the room. And so you asked the question about the recovery part. So it is true that Mr. Burke is exactly right. If the only recovery is not a court action any longer, it'll also change on that for quite some time. So between spouses, the recovery is the reconstitution of the marital estate. It's really complicated stuff, but that's the family law part of it. There is still an issue about recovery, if there is anything to be recovered, from the third party. So that would be something different, separate and apart from a division of the property that you would make in the party if you found there was something that had gone between the marital estate, but then the third party that can still be recovered, that person is their DV. I just thought I'd clarify that for you because it gets very convoluted because you've got the community estate on one side and then you've got the third party over somewhere else. And while there can't be a tort claim in between the community parties, there can be with this third party involved. So it gets really kind of convoluted in the family law context. Used to there could be torts between spouses, and now that's really no longer the way the law reads.
You're saying that there should be a recovery first. I'm not seeing that Curtis has received it. I guess potentially the $113,000 if it truly was his gas now we're trying to inherit. Seems like it's stretched. I have a jet living trial on 3 more months, and I do jet to have a wild discovery now of all of Curtis's financial information. Discover items other than possibly what was wrong with his with the issues with possible trade of income payments, that were between the two of them. It seems like it's been known about for years and years. But I'll allow the case to be continued 3 more months, but that would be it. And for additional discovery, only on the Wednesday.
Clarification on what.
Because Mr. Bird replied to this.
Well, here's what he wants to tell the court. As a farmer, he wants to be able to farm, and he wants to know how to go forward. This has been overset for 2.5 years, and the truth of the matter is that farming is different than anything else because it's his income, but it's also an asset. Okay? And so what he sees is, because this has happened over and over again, the crops he grows, they consider to make claims to those crops. We don't get to claim her salary, and it is community property and all that. My client just wants to be, if he's going to get to farm, he wants to be able to farm and go on with his life. And he's, you know, like I said earlier, I mean, it's been continued 3 times. I mean, we'll waive all discovery issues. They want to go take his deposition between now and the 21st. I mean, we'll let him do that. We'll let him look into anything. We'll get it expedited to them. That's the problem is he just wants it over. And I don't blame him after 2.5 years, 2 mediations, and the fact that he's got crops growing out there.
That is the point. Over time, it happens to cost. Getting done on the 21st, and they let you discover anything you want.
There's absolutely no way, there's no mechanism under the rules that allows us to obtain information that could be particularly from a third party. Because we could look at Curtis and he could give us the big thumb up the nose. I mean, we have no way to compel his production of those items, Your Honor. We just don't. The rules are the rules. He's either a party or he's not. And if he's not, then we've got to go through the third party discovery process. But the rules still are there to protect even third parties. If the court's not going to allow us to join him as a party, then we have to go through the third party discovery process. It's just we've run out the clock. And I think that's what they're trying to do to us, Judge, is run out the clock before we get this thing tried.
Your Honor, remember to say that again. This is really basically the third shot of continuance. I mean, I understand what Mr. Mayfield was saying the first time or the second time. Now this is the third time. And the second time it was continued specifically for this West Texas gas station. I mean, the parties agreed to put it off so that they could look into it in February. And so now we're in June with regard to this $113,000, and now they want to do it again. But that's specifically what it was done. And I will not object and have not objected. There were some of those speeches that came after the Rule 11 agreement, and I started to quash them. And Your Honor, I didn't because my client wanted to have the hearing, and I could have quashed them because the discovery basically was closed. Her response, both of our requests for disclosures and all that was over.
So this was set in February?
It was originally set in December.
Well, Judge, I'll tell you the part, because there is a new well that's been done that we've never heard about, and they gave us information about that, you know, piecemeal again. And so we needed to figure out about the new well. We went out and had to figure that out. And so then now we down in our, we get this information about this gas bill, which is April 20, whatever date that was on that check, Judge, and today's the first day I've seen that. And so we've not been given a copy of that previously. So they're saying that, you know, Mr. Curtis currently got reimbursed we've never heard that before coming here today. So, you know, as far as we knew, this gas bill, the person had paid it, and that was our machine with that person paid it. Apparently, maybe he had or had not, I'm not quite even sure to this day. But we need to be able to look into that, certainly at the very least, to figure out what's going on with that. And this check written on April 28th, you know, we never saw that till today.
I'm gonna do this. I'm gonna continue it till, when was it? September?
September 18th, I believe, is in our proposed motion.
When I'm asked to divide the assets, any cost, any income that Mr. Grow and Mr. Eric Grow has between now and then, I'm going to look at dividing the assets. So please, Mr. Grow, when it comes to that date, let me know what income he has between 21st, which is when this is set, and whatever that date of trial is. I do see this being construed as a way of Mrs. Rowan's happening today. And that's not equitable. On the other hand, Mr. Rowan, I know you're distressed, but we have some issues that I think appeals or the appeals court can agree with them that they deserve the extra time to look into it.
But speak.
Bird,
I told him no 3 times, but if he wants to speak to you.
Jeff, Mr. Mayfield?
I don't usually walk into the family law issues. I would never let my client in a civil matter, and I'm not even sure objecting is appropriate on my part, but yeah, I would object.
Okay, let's not. You can tell your attorney that he can say what he wants to. But at this point, is there anything further from?
Well, then, got it from me.
Yes.
Just a little clarification. The original motion pending before the court, motion to leave to join service.
Yes, she may join first.
Because she would grant that motion.
Yes.
Well, are you granting that he can be added to the third party, or are you granting that he can be, they can send discovery to him? Because those are different issues. Because earlier you said you weren't going to allow them, except for, okay, so you're going to allow him, but the only issue has is to the $113,000.
Yes.
Okay.
Yes.
And just so I'm clear, you're granting our motion for leave to add Curtis as a third.
Yes.
Brings us to the level 3 scheduling where you already kind of talked about that. And in fact, I think mistakenly signed it.
That wasn't a mistake. I think schedule I want to say that in my queue all the time. Usually I just ask my coordinator. They check with you, she says yes, that's fine.
But Your Honor, I found, and we were going to argue that because, and I'm not implying the court did anything wrong, what I've never seen in my life is that it is filed at the same time the motion is filed. I don't know how you did that. You're pretty good. I'm just saying. I mean, I've never in my life seen a judge sign something pretty much as soon as it was filed. I mean, it was like that.
I try to keep that queue.
Well,
You did a great job.
with the court, I mean, if we're going to play ball by the scheduling where I guess you already signed it so we don't have to unwind it and send it back or whatever you can do.
Well, but I do think you are limiting it because you're only allowing them to be added to $113,000 is what you said, correct?
Correct.
And so I think that has to be changed. Maybe.
Just clarify, yeah.
It has been clarified.
Your Honor, we will submit an additional order. We'll send it my way and get this approved by Mr. Byrd. Get this approval as to the language.
Your Honor, I appreciate that, Ms. Coffee Wade. This course would know I'm not always called by the right names.
Mike, yes, Mr. Mike.
That's right, Mr. Mike.
All right, you, Mr. Mayfield, you or Ms. Gregg will submit amended scheduling order.
Yep, consistent with the court's instructions, Your Honor.
All right.
And Your Honor, I think I'm going to submit the word you said earlier that as of July 5th, this court will not consider any income from the farm past June 21st, 2023, to be commuted, to be divided, that's all, and then in equity, you should go to him. Thank you, Ron.
I'm sorry.
This way, Judge, with all due respect, with all due respect, I don't know that that's the best way to go when all the assets aren't in front of you. That would be my only,
Let me rephrase that, Mr. Brewer, because I did say I'm gonna take it when you, at the end, when I'm dividing property, I wanna know what the income has been from the farm between now and then. And I'm gonna take that into consideration. But I'm heavily leaning toward, so we keep that in mind. Something unusual.
Thank you, Ron.
May we be excused?
Maybe.
Okay, Lynn, I think we're done here.
Okay. All right. Thank you.
We're going to end, and you can visit with your counsel by telephone, okay?
Okay.